recording and the live streaming be initiated. And Trina, you can open court when you're ready.
The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice presiding.
Will the clerk please call the case?
This is Supreme Court case CRA20-012, People of Guam, Plaintiff Appellee versus William John Pinaula, Defendant Appellant. Appearing for the Plaintiff Appellant is Attorney Jordan Pauloon. Appearing for the Defendant Appellee is Attorney Peter C. Paris. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Each attorney will have 45 minutes to argue. Attorney Paris reserves 15 minutes.
Yeah, we will correct that, Mr. Paris, that you represent the defendant appellant in this proceeding, and the people is the people would be the appellees in this case. So good morning, counsels, and Mr. Paris, you are recognized.
Thank you. Good morning, Chief Justice Carbolito. May it please the court. The first issue that I'll address is the government's motion to dismiss this appeal. And I would start by saying that I believe this court does have jurisdiction over this appeal. This court's jurisdiction, this court's powers over this appeal are extremely broad and have been conferred by the federal government pursuant to the Organic Act of Guam, 48 USC 1424-1. Pursuant to those very broad powers, which are federal powers, the Supreme Court is the highest branch of the judicial branch of Guam. It has original jurisdiction over proceedings necessary to protect its appellate jurisdiction, to have jurisdiction to hear appeals over any case in Guam decided by the Superior Court, to have jurisdiction to issue all orders in aid of its appellate jurisdiction, the authority to make and promulgate rules governing the administration of the judiciary and the practice and procedure in the courts of the judicial branch. So this power is very broad. And the government argues that pursuant to AGCA 1.25, which is a Guam statute, that this court does not have jurisdiction because in calculating time, there's a conflict between AGCA 1.25 and GRAP Rule 11. And my response to that is this court promulgated Rule 11 pursuant to its Organic Act authority. And that authority is federal. And that authority pursuant to Article 6, Clause 2 of the Constitution makes that the supreme law of the land. So
let me ask you this, Mr. Paris. I mean, it seems like you're arguing that there's preemption in this case based on the preemption of the law of Guam under the Supremacy Clause. But doesn't the legislative history of the Organic Act amendment that grants rulemaking authority to our court provide that it was not intended to preempt any state, local, or tribal law?
I believe that that's true, Your Honor. But what we have is we have an argument being presented by the government that attempts to limit this court's very broad power under federal law. And while there is a statute enacted by the legislature which discusses the calculation of time that is in conflict with our court's Rules of Appellate Procedure, Rule 11, it would be my position that this court's very broad authority prevails over the legislature's attempt to do anything to, by calculation of time, limit this court's jurisdiction. This court has, by administrative order, for example, suspended periods of statutory filings when it issued numerous administrative orders during the pandemic. And I would assert that that demonstrates this court's very broad authority to do so, and it was an application of that authority in those instances. And the court by,
don't think, though, Mr. Perez, that the issue is the supremacy of the Organic Act language over the local statute in terms of 1.25, and I think the government recognizes that. I mean, we don't have a circumstance where there's specific language similar to Rule 11 in the Organic Act and then conflicts with local law. We have a Organic Act provision that authorizes the Supreme Court to pass rules that affects process in the courts or the administration. And so I don't really see that there is this direct conflict between language in the Organic Act and a local statute where there may be a supremacy issue. And also, when we look at the basis of the Rule 11 is founded on the Organic Act provision that allow us to pass rules that affect procedures in court. And also the statute, section 1.25, the Organic Act authorizes the legislature to pass laws that are not in conflict with the Organic Act. So from that standpoint, we don't seem to have a supremacy issue that is confronted in this particular circumstance. So,
and I hear the government's argument, and I think I understand it. And but what we do have is AGCA 1.25 being a local statute. And at the same time, we've got a federal statute which confers upon our court very broad powers regarding its appellate jurisdiction. And I guess the argument, my argument is, sorry. I think there's a supremacy issue insofar as we have the government attempting to argue that this statute regarding calculation of time under AGCA 1.25, the government seeks to deprive this court of jurisdiction on that basis. And my response is, well, the basis for this court's jurisdiction is federal, and any inconsistency between on the jurisdictional issue would be resolved in favor of what the federal provision provides. This court enacted CRA20-012 pursuant to its Organic Act authority. This court exercises jurisdiction over appeals pursuant to its Organic Act authority. And again, I think those powers are very broad. And the fact that this court saw that it had the power and exercised that power to issue the administrative orders that it did during the pandemic, which suspended or told statutory filing deadlines, shows that this court has those powers and that they prevail over any local statute.
As we stated in the order seeking supplemental briefing, we have a circumstance where there is a right to appeal specified in the statute and in the rule, and it provides for how you compute the time to appeal. Rule 11 provides instances in which the computation of time is to be defined, and then we have the statute 1.25 that provides for a separate way of computing time. And I think more the question, as we've stated, is then the Supreme Court have the authority to provide for a separate, different computation when exercising the right to appeal a criminal case where there is a difference. And I think that is more focuses the issue. Does the Supreme Court have, and is there a conflict between Rule 11 and Rule Section 1.25? Because as the government argues, the government argues it can be read in harmony for the reasons it advances. And so I think, to me, that's the focus of my examination of this issue. Is there a conflict between Rule 11 and Section 1.25, AGCA Section 1.25? And if so, does the Supreme Court then, in enacting the rule, which prevails? How is the time to be computed, and do we apply Rule 11, and for what reason? Or does 1.25 control, and what is the effect of that?
And my response would be that there is a conflict because 1.25 calculates time differently for appeals than Rule 11. Rule 11 was promulgated by the Supreme Court of Guam pursuant to its Organic Act authority, and has the authority to do so. And in doing so, allows for the exclusion of Saturdays, Sundays, and legal holidays in the calculation of time in terms of calculating whether an appeal, notice of appeal, is timely. So to the extent there's a conflict, because it's federal and because the Supreme Court has acted pursuant to its authority, that the Supreme Court prevails.
What about the issue that the government raises, that the time to file an appeal is jurisdictional? And if you apply Section 1.25, that the defendant is out of time, and that Rule 11, if when you contrast and you treat it as a jurisdictional issue, the argument is that the legislature, it's within its domain to specify the jurisdiction of the Supreme Court, and therefore, for that reason, Section 1.25 should apply over a rule enacted by the Supreme Court regarding procedure.
I would submit that Rule 1.25 is a non-jurisdictional rule of procedure, and that it's non-jurisdictional, similar to the federal rules of criminal procedure not being jurisdictional regarding criminal appeals, pursuant to the case that I cited, U.S. v. Lopez, which cited Ninth Circuit case, the Ninth Circuit case, and the Supreme Court case, Bowles. And in those cases, they discussed how the federal rule of criminal procedure is non-jurisdictional. Similarly, we have a local statute, and I think that it's important to raise that this is a local statute versus the court exercising its powers pursuant to federal law. And when we compare that to how the federal courts apply the federal rule of criminal procedure, I think it's instructive to show that that rule, a local procedural rule, is non-jurisdictional. And I understand the government's argument is completely the opposite, and I understand where they're coming from, and that would be my response. And
let me ask you this, Mr. Perez. You raised the court's administrative orders that related to the coronavirus pandemic and the tolling of filing deadlines. Originally, you, in your opening brief, had indicated the appeal was timely because of the 11th and 12th administrative order. And the people pointed out that the text of those orders only told the preliminary examination and indictment time periods after October 2020, and when the appeal was filed in December of 2020, the tolling that had existed in earlier orders was not there. Is it still your position that the administrative orders 11 and 12 told the filing deadlines for your appeal?
the answer is, let me say first that it's not for me to tell the court what its meaning was behind the administrative orders, what its intent was. I will say that when I was preparing the opening brief and was preparing the jurisdictional statement, that in looking at the time, it was my interpretation of trial counsel's filing and the administrative orders that trial counsel did the filing when he did based upon the administrative orders. And when I looked at those administrative orders, it had appeared to me that that's why it was done the way it was done. And I interpreted those administrative orders this way. But ultimately, I understand there's a distinction in the language between the 11th and 12th administrative orders. And it's for your honors. Your honors know what the intent was behind those, but I read them as being broad enough to have encompassed a tolling of the appeal time. And that's the argument that we made, and that's what we put in our jurisdictional statement. I did not anticipate at all that the government was going to file a motion to dismiss for lack of jurisdiction for untimeliness. And I see where they're coming from, but I disagree with their analysis.
Well, in fact, in the government's opposition brief, they acknowledged that the appeal was timely filed before the motion.
Right, that's right. And that's correct. And I went back and looked at that again, and they did. And I believe they cited the administrative orders. I understand
People
that
seem to also take exception, although it's not an issue here, except to the extent it encompasses the issue of the power of the court. That the court, they seem to suggest that the court did not have the power to extend the deadlines that the court did under its administrative orders.
Right, that appears to be their argument. I disagree with it. Again, going back to this court's very broad powers enacted by the federal government. I think the court had the authority to do so, and it was right for the court to do so under those circumstances, and in more routine circumstances, as it does pursuant to GRAP Rule 11. This court has very broad powers to protect its jurisdiction and its power to hear appeals. And Rule 11 and is an example of that, and the administrative orders are another example of that. So again, I understand where the government is coming from. I disagree with their analysis. They cite a lot of different cases. I don't agree that those cases help them in the way that they assert that they do, for reasons including they're dealing with these state cases deal with, for example, Mississippi and Missouri state constitutions versus, our constitution, which is federal. And they don't have the conflict that appears to exist in this case between a federal statute and a local statute and our Supreme Court rules. So I think those cases don't help. And then the Supreme Court cases that they do cite, for example, Villalpando and Sanape, I don't believe that those help them either, because in Sanape, this court talked about how the appellate court cannot waive the jurisdictional time limits set down by statute and court rules, even for good cause shown. But this court, by its actions and by its powers, issued administrative orders precisely doing that, and by tolling statutory time limits, and Sanape also talked about court rules, but in this case, we don't have a violation of a court rule because Rule 11 was complied with. And arguably,
I want to go back to, because you seem to have just glossed over this jurisdiction issue in reference to the computation of time and the effect of recent U.S. Supreme Court decisions. The government, again, raises that the legislature specified that the defendant has a right to appeal, has 10 days, and that 10-day time period is jurisdictional. You mentioned the Bowles case, and there's also a more recent U.S. Supreme Court case, the Hamer case, that draws the distinction between a time period based in statute that may be jurisdictional and a time period specified in rule that is subject to what was referenced there as a claims processing principle. And that it's a mandatory claims processing that is subject to forfeiture. And so, I I just want your take in reference to the applicability of these principles and how do we determine whether or not and what authority there exists in reference to the computation of time in this particular case as to whether or not it is a substantive right or a procedural right, and how does it apply in reference to a jurisdictional treatment or a claims processing application.
First, Your Honor, I don't mean to gloss over any important arguments. There's a lot to say in a short period of time. And so when we look at the federal cases, the Supreme Court, the Bowles case, for example, the Ninth Circuit case, and the Lopez case, what they talk about is when you don't have a statute and you're dealing with, for example, a court rule, that the court rule is not necessarily jurisdictional. For example, bankruptcy rules regarding objection to claims, or motions for new trial under the rules of federal criminal rules of procedure. So in this case, we do have a statute, but we have a local statute. And the local statute, Rule 1.25, talks about calculation of time. At the same time, we have Rule 11, which is a rule promulgated by our court, which also talks about calculation of time, which controls. Government argues that that 1.25 controls because it's statutory, because it's not in conflict with Rule 11. And I say there is a conflict because the calculation of time regarding the ability to appeal is different for each statute, the statute versus the rule. But where does our rule come from? Our rule comes from federal law. So my argument then becomes federal law prevails over the local law. And the secondary argument is Rule 1.25, I would submit, is non-jurisdictional. It is procedural and similar to Federal Rule of Criminal Procedure 33, which is a criminal procedural rule versus a jurisdictional, which is a jurisdictional statute. Now, I know that there may be disagreement regarding that argument, but that is the argument that we advance on this appeal. And we think
but can we just back up a bit? Because you just said that the statute and the rule conflicts, and the government says, no, you can read it in harmony, and gives the reasons, articulates the reasons why you can read it in harmony. How is it that, can you explain how this AGCA 1.25 and its computation of time conflict with Rule 11? Other than one is 7 days and one it's 11 days, and you include weekends and exclude weekends and holidays when in the application of one rule as opposed to the other. But how do these rules conflict? Can you articulate that for me?
They conflict in a person's ability to access appellate rights. They conflict in a person's access to your court, because the local statute says that you calculate that time one way, and maybe and we say that's procedural. Government says it's statutory, versus Rule 11, which calculates it a different way.
Yeah, but the government argues that Rule 11 applies. Rule 11 applies in computing any time period specified in these rules, in any local rule or court order, or in any statute that does not specify a method of computing time. And the government's argument is that the statute that gives rise to I think it's 130.40 gives a statutory right to appeal. If you look, although that doesn't specify the time period of how you compute that 10 days, there is the corresponding statute, section 1.25, that does provide how to compute the time period. And there, if you exclude Saturdays and holidays, Saturdays, Sundays, and legal holidays, when the period of time is less than 11 days. And here it's, time period is 10 days. And so the argument is that Rule 11 by its own terms says that in any statute that does not specify a period, which is 130.40, when read in conjunction with 1.25, it does specify how you compute the time period. Therefore, the government argues that Rule 11, by its own terms, when you read it this way, doesn't apply. So what is your response to that argument, where you conclude that it does conflict, but I don't think you explain, at least not to me, how it conflicts?
Let me say I would have been more careful if I were trial counsel in making sure that the notice of appeal was filed in a more careful way. And here we are, trial counsel filed the notice of appeal in accordance with Rule 11. Government argues, points out that Rule 11 talks about timeframes when you don't have a time frame articulated by statute, as you do in 1.25. We have to respond to that. How do we respond to that? Well, we say 1.25 is non-jurisdictional and it's procedural, and you've got two procedural provisions. 1.25, procedural non-jurisdictional is the argument, and Rule 11, based upon the Organic Act, which is very broad. I mean, there are limited arguments I can make, and I think the arguments that we advance have merit, and I think the government's arguments similarly have merit. And I have not seen this issue raised before. And I mean, what if the court says there's no jurisdiction, then I've got a guy who's been in jail, who's got an 8-year sentence. So what do we have to do? We then have to say, okay, maybe there was ineffective assistance of counsel because you had an untimely filing of a notice of appeal, go file a writ of habeas corpus. Or we say, okay, we disagree with the decision regarding the jurisdictional issue. Go hire a lawyer and file a federal writ to have this issue interpreted further. I mean, this is a situation we find ourselves in. But I do think that there's merit to the argument that because the Organic Act is supreme, this court had the authority pursuant to Rule 11 to calculate time for its appeals and very broad powers thereunder to protect that appellate jurisdiction. This court has done it through its administrative orders, and we understand the government's arguments, and it's an issue that I haven't seen before. So,
well, let me just say that I don't mean to suggest that there is no merit in your argument. Otherwise, we wouldn't be struggling here. It's a meritorious argument on both sides, and we are struggling to arrive at a resolution. So I don't mean to suggest at all that there's no merit in your arguments.
Oh, thank you.
Can we go to the merits of the appeal? The defendant was convicted under a provision that appears the facts would support that he either retained the truck knowing it was stolen. And you have conceded somewhat that your argument that the statement about it belonged to his friend was improperly admitted. Is that the only evidence that stands to support this conviction?
That is the only evidence, yes. And secondly, I didn't mean to suggest in my argument that we conceded that we were waiving our argument that was inadmissible hearsay. We concede that admissions by a party opponent are admissible, but we don't concede that this was an admission by a party opponent. An admission would have been, hey, I brought that truck here, and I received it, or I retained it, or I know that it's stolen. That would have been an admission, but there was no admission offered as an exception during trial, and of course there was no objection made by defense counsel that the testimony was inadmissible hearsay. But the answer is yes. Without that nexus, there is no evidence whatsoever. Yes, the truck was found in an abandoned property near where the defendant lived. Is that sufficient evidence to say that he received and retained it? Because there was no evidence to show how it even got there and whether or not my client knew that it was stolen. I think this case is very flawed in terms of sufficiency of evidence.
Well,
And
let's look at the elements. The first element of received and retained the property. If the admission by him to his uncle that it was his friend's truck was admissible, then it seems to me that there is proof that he received and retained that property. It was his friend's truck somehow or another, and that can be proven by that testimony and then the other evidence where the truck was discovered. The second, knowing that the property had been stolen, wasn't there circumstantial evidence of alterations to the truck, that it was broken into, the steering column had been adjusted, there was the hose reels on the truck that had been removed, and as well as the compressor had been tinkered with on the truck? I mean, and don't those suggest that these alterations to the property, that the property had been stolen?
when a jury evaluates a case, it's prohibited from speculating. Yes, it can weigh circumstantial evidence. Yes, that evidence was there regarding the condition of the truck, but there was zero evidence that my client knew that the condition of the truck was what it was when it was discovered. In order to establish that nexus, the burden of proof would have been on the government to establish some form of evidence to establish that nexus, and they did not do so.
There seemed to be some confusion in the record when I read it, and even by arguments by counsel regarding that the wheels were removed from the truck. And, you know, obviously if you have a truck in the yard and the wheels were removed, that could be circumstantial evidence again that the truck had been stolen and the parts had been pilfered. But it appears that that was not the case, that the wheels were still intact on the vehicle. And so what were the physical signs that were present that showed that the truck was stolen, besides the alterations that I had indicated earlier? Are there any other physical signs that the jury could infer circumstantial evidence that the property had been stolen?
Not that I recall, Your Honor. And even if the tires were removed, what was the evidence that Mr. Pinaula was aware of that? What is the evidence that he was aware of why the tires were removed? There wasn't even evidence as to whether that truck was on his own property. The government didn't establish. They said it was in the area of his house, adjacent to his house, about 100 yards from his house, on a property. It was like an acre lot, and the government didn't establish that it was on his property or Herbert Pinaula's property or another person's property. There was no evidence to that, only that it was near. But even the prosecutor argued to the jury that was abandoned. And I don't want to say things out of context, but when we look at the language given by the prosecution in its own arguments, they talk about all of the flaws of their case. Anybody could have done it. It was abandoned. Language like that. Anybody could have done this. It's an imperfect case, bad police work. There's a lot of things missing. Well, the burden of proof is on the government. And, basically what they're doing is they're saying, okay, there was a truck found 100 yards from where my client lives. That's the evidence. Unless the testimony of Herbert was properly admitted. And even if it was, I would submit that still does not establish a sufficient nexus to satisfy the burden of proof. This is beyond a reasonable doubt. It's not a preponderance of the evidence. And I would say this is probably one of, other than the other appeal I recently argued, which I lost, I would say that the sufficiency of proof is extremely deficient in this case, to the point that acquittal is warranted. The elements of the offense were not met: receiving, retaining, or disposing of the movable property. Who saw him receive it? Who saw him retain it? There's no evidence he brought it there, knew why it was brought there, intended for it to stay there, that he intended to deprive the owner of it, that he knew it was stolen. None of that. That would require the jury to entirely speculate. And, you know, in our opening and reply briefs, we itemized all of the deficiencies in the trial evidence. And when we look at the witness testimony, not one witness other than Herbert Pinaula connected Mr. Pinaula to the offense. Detective Mondia executed a warrant at Mr. Pinaula's residence and found nothing incriminating. The other officers did not find anything incriminating regarding Mr. Pinaula, nor did Rene Molinos. He agreed he wasn't accusing Mr. Pinaula. So Mr. Pinaula, the uncle, says that William said it was his friends. If that was properly admitted, is that sufficient, even circumstantially, to prove the essential elements of the offense? No, we would submit not. Then the other deficiencies are, you know, you can't argue these bookend arguments, government, that, you know, he's involved and therefore he's guilty. And, you know, use a sleep test analysis, because then you violate the Organic Act, the Fifth Amendment, the 14th Amendment, all of the rules, all of the criminal procedure rules regarding burden of proof, presumption of innocence, elements of the offense, culpability. Those arguments basically dispose of all of those to the jury. And even looking at the standard for prosecutorial misconduct, in the sense that these were improper comments made. And yes, you have to find it's extensive. The times in which they were made, the bookended nature in which they were made, the lack of a specific instruction from the court. I understand no objections were made, but the lack of specific instructions from the court, you know, for the jury to disregard those and follow the requirements for burden of proof, presumption of evidence, et cetera. In a very weak case, support a plain error result, I would submit, and acquittal. That's my presentation. Unless there are any questions, I'd like to reserve the balance.
All right, thank you, Mr. Paris.
Thank you, Your Honor.
Mr. Paloon, you are recognized.
Mr. Chief Justice, and may it please the court, my name is Jordan Paloon and I represent the people of Guam. In this case, we ask this court to do one of two things. Either first, dismiss the appeal for lack of jurisdiction because the notice of appeal was untimely filed. Or two, alternatively, affirm the judgment of conviction entered by the court below because the prosecutor's statements were proper and there was sufficient evidence to support the convictions in this case. This case really involves two big issues, jurisdiction and then the underlying merits of the convictions itself. And so I will address each of those in turn. Related to the jurisdictional argument, the statutes require that a notice of appeal is filed within 10 days after the entry of the judgment of conviction. That is found in HECA 130.40. In HECA 130.35, it indicates that the timeliness of that notice of appeal is the only thing that impacts the validity of the appeal. So that is the only jurisdictional step, is the timely filing. And there is a statute that indicates how to compute time under Title VIII, and that is section 1.25 of HECA, which indicates that you count every day unless the last day is a Saturday, Sunday, or legal holiday, unless the period is less than 7 days. In this case, we have a period of time, 10 days, which is greater. So you will only exclude a Saturday, Sunday, or holiday if it is the last day of the period. And so in this case, I think if we look at the plain reading of the statute, the notice of appeal was untimely. The there's a lot of discussion about the application of Guam Rule of Appellate Procedure 11 and the calculations under that rule. I concede that the mathematical calculation portion of that rule would yield a different outcome. However, we also have to read the first part of Rule 11, which indicates what types of things that rule actually applies to. And it applies to court orders, it applies to court rules, and it applies to statutes that do not otherwise specify a method of computing time. And
Why
Title 8.
doesn't the first exception under Rule 11, computing any time period specifies in these rules, make Rule 11 applicable?
Because the 10-day period of time is found in both the statutes and the rules. And so we also have to look at the statute for the jurisdictional timeliness of this.
Well, you originally said they were not in conflict and that they could be read in harmony, but now you recognize that they are in conflict. If you say that you apply the rule in computing a time period specified in these rules, then clearly Rule 11 and 1.25 are in conflict.
I do not agree that they are in conflict. How I read it is, if we look at only the Part B of that, the mathematical calculation, that yields a superficial conflict. However, when we look at what the rule actually applies to, and when we're looking at the timelines in the statute, it does not apply to AGCA 130.40. It actually defers to the statute and the calculations of time in the statute.
How do you read that? Why do you read the beginning part of computing time? There's 3 tests for it. It applies in computing the time period specified in these rules. It implies in a local rule or court order, and it applies in a statute that does not specify a method of computing time. There's nothing that indicates when it applies in more than one of those situations, which one takes precedent. And
So when there is a statute that specifies a timeliness, that is a jurisdictional requirement that common law and the United States Supreme Court and this court has consistently recognized as a jurisdictional requirement. This court has consistently held that filing of a timely notice of appeal is both mandatory and jurisdictional. So
I
I
just don't think that we're at that juncture of the discussion, just in terms of Justice Torres's point, first of all, to see if Rule 11 first conflicts with Section 1.25, because you say it doesn't, and Justice Torres pointed out that the first part of Rule 11, by its own language, says in computing any time specified in these rules. But I think what next needs to be pointed out, that these rules, there is GRAP Rule 4B, 4B1A, that says that it provides a 10-day window in which a defendant has to file an appeal. So within the GRAP rules, there is a provision that says, GRAP Rule 4B, that the defendant has 10 days to file an appeal. When you correlate that with GRAP 11A, that in computing any time period specified in these rules, there is then the rule says that you compute it according to Rule 11 in computing the 10-day time period. So the argument is that there is a direct conflict between Rule 11 when read in conjunction with GRAP 4B and Section 1.25 in conjunction when read with 130.40. So I think the first point that we are asking to be clarified is there a conflict between the rules? And because in your brief you said that there are no conflict, but I think what Justice Torres is pointing out, that there is a seeming conflict when you read GRAP 11 with Rule 4B.
So I think so let me take my analysis a step backwards and it might answer that question. If we're looking at GRAP 4B for the timeline for the notice of appeal, then there may be a seeming conflict between GRAP 4 and the statute, HECA 130.40. However, being that the timelines and timeliness are specified in a statute, that's where I get to
there is no conflict there, Mr. Paulun. Both provides for 10 days. It's how you compute the 10 days.
And how, yes, and how you would compute the 10 days under the statute would then indicate that the outer limit of the statute and how you compute that is the ending period.
But the question now is which applies. I mean, if both applies and there is a conflict, which takes precedent. And I think what Mr. Paris points out, that recent US Supreme Court cases now say statutory time periods, if the time period to appeal is specified in rule, then it is subject to a claims processing analysis. And if it's based on a statute, which 1.25 is, then it's jurisdictional. But the analysis doesn't stop there. You then, according to recent US Supreme Court case, you need to first step determine, is it one of substance or one of procedure? Is the computation of the 10-day time period one of procedure or one of substance? And I think that's the next step of the analysis.
So I think that this case doesn't just come down to a computation problem. It will also come down to looking at the difference between...
Internet, things have changed and we need to talk. This photo, I thought it was private.
I'm sorry, I don't understand. Where's that coming from?
It's not clear to me either.
So I don't know either. So we have to look at the difference between section 130.40 and potentially GRAP rule 4 then. And I think it's also clear from United States Supreme Court case law that even if a court tries to make a court rule that would expand its jurisdiction and expand those timelines, it cannot do that. So 130.40 and the calculations...
There's no expansion. This is not a case whether or not the Supreme Court is in some way articulating when a defendant may appeal or whether he has a right to appeal. This is a case in which the Supreme Court has passed a rule that specifies that a defendant has the right to file a criminal appeal, Rule 4B, and has 10 days to do so. And that tracks the statute. So there is no issue of the Supreme Court expanding its the defendant's right to appeal and affecting its jurisdiction in terms of the right to appeal. It is at least in my mind, an instance where if you are going to exercise that right, the rule provides, Rule 11 provides a manner of computation that if applied in reference to Rule 11, that it was timely. However, if the statute it controls and that this is one of substance in reference to the manner of computing the time, then it would seem that that's jurisdictional and that the statute would control.
So the timeliness of a notice of appeal has always gone to the power and substance of the court and hasn't been held to be just a matter of mere procedure when it comes to the cases. If you look at Bowles, for example, court orders and court rules couldn't extend the were not jurisdictional rules, and prior cases.
But the question is, we're not extending the time frame from 10 days to 12 days to 15 days to 30 days. We're just providing a manner in which the calculation of the 10-day period is determined. And GRAP 11 provides a different basis than doing so than 1.25. But both GRAP 4B, as the Chief Justice pointed out, provides a 10-day window. It's still 10 days to file the notice of appeal.
So GRAP 4B, while it tracks the statute's language, is not the statute that confers the right to appeal in a criminal case. That's section 130.40. So when we're looking at that statute, we calculate the time based on the method contained in the statute, not within the court rules. And so I think a hypothetical here would also be useful in if the court would, for example, say, well, we adopt a rule that for calculating time that we only count the first Monday of every month, then we would essentially the court would essentially be able to expand, in contradiction to section 130.40, the time period for filing a notice of appeal from 10 days to 10 months. And in that case would be, I think, a relatively clear expansion. And in this case, what it has done is, by application of GRAP 11 to the time period found in 130.40, which would be the statute creating the substantive right to appeal, has expanded the period of time specified by the legislature, and the legislature has specified how to count that. And so by applying GRAP...
Yeah, but I mean, does that then mean that we should examine what the legislative policy is that's furthered by section 1.25? What is the purpose for that requirement other than judicial administration? Doesn't that seem to be a calculation that the court is better suited to deal with?
It also deals with principles of finality and things that have been historically understood to be within the common law power of the legislature. I cited cases in my brief going back several hundred years about the timeliness of a notice of appeal being a jurisdictional requirement. It's really a time-honored jurisdictional requirement found in the cases. And so if we look at the plain language of the statute, it's really saying, Supreme Court, you can review these on appeal, but in defining the appealable judgment and order, it says, criminal judgments appealed within 10 days, and by 10 days, we mean this. For the Supreme Court to come in by court rule and apply a different interpretation would be to chip away at the legislature's authority to define what is an appealable judgment or order.
Is it possible that when you look at 8 GCA 1.07 that talks about the general applicability of these provisions, it talks about them applying to the governing the practice and procedure in criminal proceedings prosecuted in the name of the territory. Is it possible that this provision doesn't even apply to the notices of appeal and the 1.25?
So if we're looking at Title 8, so it would apply to those that are prosecuted in the name of the territory, because this is Title 8 is about criminal cases, and this case has been prosecuted in the name of the territory, the people of Guam. And so I think that these are 1.25 applies in all criminal cases to the methods of computing time under the statutes there, and the notice of appeal requirement and the right to appeal are specified by the provisions in section 130 of Title 8. So this would apply in those circumstances. HGCA 1.25 specifies the method of computing time for things that are found in Title 8.
The legislature approved the initial Guam Rules of Appellate Procedure by public law back in 1995, Public Law 23-34. And at that time, the method for computing time was materially similar, not identical to the time set forth in 1.25. But the legislature, when it adopted and passed those rules, the rules authorized the court to amend its own rules, and also stated that the interpretation of the rules as promulgated by the Supreme Court allowed us to amend it, and the rules as promulgated by the Supreme Court, the interpretation of them would be done by the Supreme Court and would be controlling in all counts. Why doesn't that then give us the authority to determine the Rule 11 in conjunction with Rule 4B applicability?
So when it comes to the ability to promulgate the rules, nobody, even the people, challenges this court's authority to promulgate the rules. But when we're looking at the specific statute that grants the right to appeal, not talking about we're not talking about all the procedures after the fact, but the actual just initial timely notice of appeal, that's 130.40. And that's dictated by statute. And if we look at GRAP 11, GRAP 11 just doesn't apply to statutes that otherwise specify a method of computing time. What GRAP 11 does is defer to the calculations contained in the statutes.
But GRAP 11 also says if it's in the rule applies.
But the rule itself is not the thing that creates the jurisdictional limitation. If you look at the Bowles case, for example, there's a clear distinction between claims processing rules and jurisdictional requirements. And jurisdictional requirements are those things found in statutes. And in Guam, unlike the federal counterpart, the timeliness of a notice, the timelines for a notice of appeal in a criminal case are founded in statute. There is in federal law, there is only a court-based rule for timeliness of a notice of appeal.
Well, 1.25 is not specific to notice of appeal. It's just a general computation of time. The timeline for the notice of appeal is set forth in a separate provision that sets forth the 10-day window, and Rule 4B, which provides also an appeal be done, is also a 10-day window.
So yes, but also if we're looking at section 1.25 that applies to the entirety of Title 8, Title 8 is the entirety of the statute itself. And then there are subsections delineated 1.25, 130.40, et cetera. And so the statute, Title 8, specifies its own method of computing time that applies to the whole thing. I think it would be quite redundant to require the legislature to copy and paste the method of computing time to each section that subsequently follows within the same title. Then we would then have them specifying that every single time. And an economy of actually drafting statutes and codes, you do it once at the beginning and apply it to the remainder of
Mr. Powell, let me go
sections.
back again. And I don't think anyone is arguing that the legislature has the authority to create the right for the criminal defendant to appeal. The legislature has the authority to specify that the time period is 10 days. However, to me, the issue is if now we have a court rule that says how you compute the 10 days for purposes for determining how when it expires. And if you have a statute that say there also is a statute that specifies how the 10 days, and that there is a direct conflict between a court rule that defines how you compute the expiration of the 10 days and a statute. Doesn't recent U.S. Supreme Court case say that in reference to deciding which controls, you look at whether or not that issue is substantive or procedural. So we're not talking about the right to appeal. We're not talking about the outer time period in which is specified. We're talking about how you compute the expiration of that 10-day period. And doesn't recent U.S. Supreme Court say that you look to whether or not that is a substantive application or a procedural application? And how do you view, assuming that's the case, the computation of time in determining whether or not it expires or not? Is that substantive or is that procedural?
In this case, it's substantive. The distinction made in the U.S. Supreme Court cases between the substance and procedural thing is in identifying whether a statute creates a jurisdictional or mandatory claims processing bar. It's pretty uniformly held from the United States Supreme Court that court rules are only mandatory claims processing rules. The court cannot define its own jurisdiction on those terms. Then statutes will fall into one of two categories: jurisdictional, which relate to clear statements and substance, or things of less clear statements or procedural things would fall into a mandatory claims processing rule. I think here, if you look at section 130.35, the legislature has spoken almost as clearly as it can on the timing requirement that the only thing affecting the validity of the appeal is the timely filing of the notice. And so they have spoken in pretty clear terms that this is a jurisdictional requirement relating to what is an appealable order or judgment and the power of the court to review cases. And so if we look at that, then this is something that falls into that category. And what we're not doing is we're not comparing GRAP 11 as it applies to GRAP 4. What we're looking at is, how do we define the 10-day period found in section 130.40? And the method of computing time that controls there and is deferred to by GRAP 11 is that found in section 1.25. And so the statute circumscribing the limitations here defines its own thing, and GRAP 11 defers to that.
So if the court wanted to modify how it's computed, the 10-day time period that's specified in 130.40, and it conflicted, in this case, 1.25, you're saying that the Supreme Court would not have the power to enact a rule that determine how that 10-day time period is to be computed in reference to governing procedures in that's the language specified in the Organic Act, that the Supreme Court has granted the authority to pass rules affecting procedure and process in the courts of law.
I'm not taking that position at this point in time because I don't think that this case implicates that issue. What we have is a jurisdictional time limit set by section 130.40. That's the 10-day period that we have to analyze here. And GRAP 11 defers.
And I don't think anyone is contesting that it's 10 days that's specified in the statute. But the statute in 130.40 doesn't say how you compute that 10-day time period. You have to look at 1.25. And so the question then is that whether or not the Supreme Court can then enact its own rules specifying how 130.40 is to be computed.
Maybe it can and maybe it can't, but it hasn't done so in this case. It has deferred to section 1.25 because if you look, HECA 130.40 is not a statute by itself, is a section of a larger statute known as Title 8 on criminal procedure. And so what they have done in Title 8 is specified how methods of computing time are determined under that under Title 8. And then in section 130.40 is where we find of that statute is where we find the time limitation. And so what the court has done in GRAP 11 is said that this rule just does not apply to statutes that otherwise specify a method of computing time. And because Title 8 as a statute specifies a method of computing time, GRAP 11 does not apply to it. The calculation set out in section 1.25 is what controls in calculating what the legislature means by the 10-day period. I think that there are reasonable arguments in both directions as to what the Supreme Court's authority is under the Organic Act to promulgate rules of practice and procedure. I don't concede that they can expand their own jurisdiction. My initial inclination would be that would be a little bit beyond that. But at the same time, that that dichotomy between those things is not implicated here because we have the jurisdictional statute and the court rules defer to a different calculation of time, not their own.
I
And so
understand.
if there are no,
You may want to proceed to
Yes.
the merits argument now.
I was
Can
going to say, if
ask
there are no
you
more questions
about
on,
the evidence specifically related to the element that he knew the property had been stolen. I understand obviously the evidence presented at trial is viewed in the light most favorable to the people. But it seems there's some gap between showing that he knew that the property was stolen, even if he satisfied the received and retained the property under the elements that are required.
so he doesn't even need to necessarily know that the property's stolen. He might just need to have a reasonable belief that that it might be stolen under the statute. If he knows it to be stolen or believes that it might have been stolen, then he has a duty to do something about it. Otherwise, he's in violation of the statute. If you look at the
statute, it's knowing or believing that it has probably been stolen.
Yes.
Yes.
And there is testimony on the record that Mr. Pinaula did not work for a construction company, had not worked for a construction company. And here's this truck that his uncle testified was sitting in his backyard that bore the label of a construction company on the side of the vehicle. There was video surveillance footage that showed an unidentified individual removing the truck from the construction company's lot. And then the construction company also testified, individuals from the construction company also testified about GPS tracking that they had attached to this vehicle that showed the vehicle go from their lot straight to the area around the defendant's residence, circle the area of the residence several times, and then come to sit within his backyard area in a field behind his house. Then his uncle, who indicated that he didn't know why that was there and asked his nephew about it, who lived next door. His nephew indicated that it belonged to a friend. So he would have had some indication, Pinaula would have had some indication that he knew that it was there, he possessed it being in his backyard, and that with the labels on the side, as well as the fact that things were being stripped from it, that it was likely not something that was intended to be used, but was something that was actually stolen. There's a reasonable.
What was the evidence that showed he looked in the cab or was able to determine that these parts were stripped? I mean, if you see the car parked there, if your friend came up and said, "Hey, I'm going to park my truck here," and he said, "Fine," and you can't tell by just looking at the truck from afar necessarily that it appeared to have been broken into and had been stripped out inside.
So if you're looking,
is there any evidence that shows that he was cognizant of that?
So his statement to his uncle that he indicated that it was his friend's, as well as the fact that it's located within his backyard in a relatively short distance from his house, is enough circumstantial evidence for the jury to reasonably believe that he knew or would have known. Like they can find that's sufficient evidence that they can conclude beyond a reasonable doubt that he did that. They could have concluded the other way if they didn't believe the testimony of the uncle and other things. But in the credibility determinations between the uncle's testimony and other things, the jury believed that. And that's within the province of the jury to do that.
Yeah, but even the uncle himself, when he was asked about whether he had any suspicions about the vehicle, he said, "No, because I've never known him to bring something back there that didn't belong to us."
And so, but that's why he was suspicious of it, because he knew that it wasn't something that that actually belonged there. And so there was the video surveillance showing it and then circling the area of the defendant's residence and then coming to rest in the defendant's backyard is significantly strong evidence that he knew that it was in his backyard, along with his testimony that it was from a friend. So he would have known if when confronted by his uncle, he says that it belongs to a friend, he knows that it's sitting in his backyard. And so he would have received or retained stolen property from his friend.
I can get to where he had received the property. I mean, and that I fully understand the circumstantial evidence. I have difficulty grasping that he was aware or had a reasonable belief that it was stolen if there's not a nexus to show that he somehow observed the truck, the cabin of the cab of the truck that showed that it had been broken into, or that there was some testimony. Because when you look at it, you're not able to say, that the compressor was being removed, that the bolts might have been removed, or that some of the reels from the hoses were there. I think there was testimony at trial, and there seemed to be some confusion that said the wheels were gone from the truck. But obviously it doesn't seem that that was the case based on the pictures that had been submitted into evidence. And so I wonder if there was confusion as to where the wheels stripped, and therefore that was further indicia and circumstantial evidence of there being a stolen vehicle.
And whether it was the vehicle or the hubcaps, one of the officers did testify that there was significant damage done to the vehicle. So it was not just some bolts were removed, it was significant damage that was testified to. And so if we're looking at the photos and other things like that, it's for the jury to determine, looking at those things, whether the damage indicates knowledge to that extent or not. And those are facts for the jury to weigh, not for the court to weigh. And so I think looking at all of the evidence and the testimony, there is sufficient evidence for the jury to reach that conclusion.
But Mr. Paris says there's no evidence to show that his client was aware of the condition of the vehicle.
So absent testimony from criminal defendants, we have to rely on circumstantial evidence of knowledge. And in this case, it's a corporate vehicle sitting outside of his home with significant damage to it that he indicates that he knows it was there. And so he doesn't even, and so the knowledge that it belongs to a construction company, and without any indication that him or his friend works for that construction company, and he doesn't work for that construction company, is pretty strong evidence that this is a stolen vehicle. That, along with the damage to the vehicle, would be sufficient evidence for the jury to determine that he knew it was stolen. Or even if he didn't know for sure, is enough that he should suspect that this vehicle is likely stolen. So I think if we look at all of the circumstantial evidence in this case, it really points to the conclusion that there is sufficient evidence, and it has to be viewed in the light most favorable to the people. And the jury is entitled to make the credibility judgments, weigh the evidence, weigh the facts and circumstances, and reach that conclusion. And so if you have video surveillance of a truck being stolen, GPS tracking, showing the truck move from the lot to the defendant's residence where it was later found in his backyard, the truck had a label of the construction company on the side and was testified to as having significant damage. The jury can reasonably conclude from those facts that he retained knowing or likely knowing likely stolen property, knowing there was stolen or likely stolen property.
Wasn't there evidence that the vehicle was difficult for the people who are looking for it to find it because of vegetation? Doesn't that suggest you might not have seen the details of the damage?
Or that's further indication that him and his friend hid the vehicle in order to try and prevent it from being seen by cops or business people that are coming to look for it. So if his friend arrived with this and they interacted, we don't know, but there's circumstantial evidence in his statement that he got it from a friend that could be evidence that it was placed there because they knew it was stolen, not just as to obstruct his view, but if he knew about it and knew his friend placed it there because they wanted it out of sight, then the jury could conclude that that's further evidence that he would have known that it was stolen or likely stolen. And so if his friend placed it in these bushes to hide it, that's also evidence that they know that they've done something that they shouldn't have done. And the jury gets to make that choice. So moving to the other argument related to the merits is Pinaula's argument that the prosecutor made statements that were inappropriate. If you look at the entirety of the opening and closing arguments, the statements made here were proper and were just helpful to helping the jury understand the facts and circumstances in the case and to evaluate it fairly based on their judgment and experience and after listening to all of the facts and circumstances. There was the statement made in opening arguments related to if he's involved, that's all you need. That statement is being singled out in isolation to be erroneous. That statement was used by the prosecutor for a very specific purpose to help a jury understand the difference between theft by receiving, which is more of a possession crime, from what is traditional theft, where somebody is being charged with doing the actual taking of property. And so when somebody goes on trial for theft, a jury is usually looking for evidence that that person needs to have done the taking. However, theft by receiving crimes don't require that. They just require somebody to retain, receive, or dispose of stolen property. And so what the prosecutor was intending to do was to help alert the jury to the difference between those two things. And just because Pinaula's friend may have helped move the vehicle from the construction lot to the house, and we don't know the identity of that friend, that does not mean that Pinaula cannot be held responsible for his part in the crime. Additionally, related to the closing arguments and the discussion of the burden of proof, I think if you look at that statement related to the sleep test, the prosecutor was started by first reminding the jury that it was his burden of proof. He then moves through evaluating both sides of the case. Are you comfortable with the verdict being not guilty or guilty? So he doesn't side it one way or the other, and uses it to help the jury manage understanding what their role is in the case, and to ask them to bring their life experiences and understanding to the case, which is what we ask jurors to do when they're evaluating the evidence. The other portion of this is that in the closing statements, defense counsel similarly relied on the sleep test, even saying that he liked it and encouraged the jury to rely on it. Even if there is any error in the sleep test, it would certainly be a self-invited error at that point in time. The defense counsel can't invite the jury to rely on this test and then subsequently argue that the jury erred in relying on the test. The other thing too is opening and closing statements are not evidence in a case. What they are a time for the prosecutor to help explain the case, what's going on. They're not expected to get up there and give robotic recitations of facts and certain circumstances to a jury. What they are up there to do is help explain to the jury how this case works, using the human element, using their own reasoning skills. How can you think about a case? And then at the end of the day too, the jury was properly instructed by the court on the burden of proof and on the elements of the crime. And we trust that juries will follow the law in the case, follow the court's instructions, and there's no indication that they would have not have done so in this case. Further, on the opening and closing statements, this case does arise under a plain error review. And so the burden is on the defendant to show that this was clear and obvious error and that it affected his substantial rights. And if we're looking at the briefing and the issues on this, they haven't met that burden. Pinaula has not demonstrated that this is clear and obvious under existing law. There's no case on point demonstrating this. In fact, the people had cited the case of People versus Howard out of Michigan, where a very similar statement was found to not be error. When a prosecutor asked the jury, "Can you live with yourself if you return a certain verdict?" That case was a reasonable tool and rhetorical device used by the prosecutor in that case to help explain it to the jury and encourage them to make fair assessments of the case, not based on emotions and other things, but based on the evidence and careful evaluations of it. And so looking at cases like the Howard case, which is from Michigan, which is also a model penal code jurisdiction, which Guam relies on heavily, we find that there is no clear and obvious error, even if this court would find that it was erroneous. And Pinaula has not made the requisite showing that it would have been outcome determinative under the third prong of plain error. I will address one last point that came up that I had believed was conceded in the briefing related to the statement of a party opponent. In criminal cases, statements made by the defendants to other people clearly fall within the rule that it is a statement of a party opponent that is not within the definition of hearsay. And my reading of the briefs was conceded, but I also think a plain application of that rule, if the court does reach it, indicates the propriety of admitting that evidence, which further bolsters the jury's view of the case and helps them understand the defendant's knowledge and requisite intent in receiving, retaining, or disposing of stolen or likely stolen property. So for those reasons, we ask this court to do one of two things. First, we ask this court to dismiss the case for lack of jurisdiction based on an untimely notice of appeal, or alternatively, we ask this court to affirm the judgment of conviction because there was both sufficient evidence to support the verdict in this case, as when viewed in the light most favorable to the people, and none of the statements made in closing or opening arguments were erroneous, and certainly not plainly erroneous at that. So for those reasons, we ask this court to affirm or dismiss.
Thank you, Mr. Pallone.
If we were to adopt the rule that you suggest, that 1.25 prevails, would the decision of this court be prospective only?
I believe that it would be prospective. I have not looked at all of the permutations of how it would apply, but I will give an example of where jurisdictional rulings have been prospective when they have changed certain historical understandings and practices. In Oklahoma, for example, the United States Supreme Court in McGirt changed the understanding of jurisdiction over tribal lands, which called into question actually over a century of criminal convictions by the Oklahoma courts. The Oklahoma Supreme Court of Criminal Appeals, it's the Court of Criminal Appeals, which is their highest criminal appellate court, has held that that case is not retroactive because there are principles of finality and other things at play. And I see that I'm out of time if you have any other questions.
No, that was it. Thank you.
All right. Thank you, Mr. Pallone. Mr. Paris, you may use the balance of your reserved time.
Thank you, Your Honor. The government says that at the beginning of opening statements, they say that Mr. Pinaula was involved, and that's enough. But that is not, that's a statement by the prosecutor to the jury, and that is an improper statement. It is, in fact, not enough. This was not a case where the prosecution charged Mr. Pinaula with a theory of complicity, conspiracy, or criminal facilitation. And they were obligated to prove the elements of theft by receiving beyond a reasonable doubt. And this was required by the Organic Act, the Fifth Amendment, 14th Amendment, by our statutes, 90.21, proof of elements, 90.25, reasonable doubt, 4.10, voluntary act required, 4.25, culpability, 4.30, culpability applied to the elements of the offense, and 4.40 regarding mental state. So when the prosecution tells the jury that, they're telling them an improper, incorrect standard. And that is misconduct. And when they say at the end of the case that you can apply a sleep test, and they say that even though the burden is there, is you can never put a number or percentage of how sure you should be, both of those things are not true. The prosecution has the burden beyond a reasonable doubt. And there is a percentage. The percentage is certainly beyond 50-50, because that 51% is a preponderance of the evidence. So there are percentages that might apply. So that was also an improper statement by the prosecutor. And in saying that,
Are you saying then that that statement changed the definition of beyond a reasonable doubt?
it did. It suggested to the jury that beyond the reasonable doubt could be 40%, 30%, 20%, 10%. That's not accurate. Beyond a reasonable doubt is defined. Yes, there is not a specific percentage, but it's certainly beyond 51%. And in telling the jury to apply a sleep test, the prosecutor is telling the jury to disregard its duties to hold the prosecutor to its burden of proof and to its obligations to prove each element of each offense beyond a reasonable doubt, to apply the presumption of innocence, and to apply all of those statutes that I just referenced to their evaluation of the case. And the statements made by the prosecutor basically acted as bookends. So they introduced the case saying he's involved, that's enough. Then they concluded the case by saying, apply a sleep test when you evaluate this case. And while there were general instructions given by the court to the jury, those instructions I would submit were insufficient to cure the error. And I recognize no objections were made, so it's a plain error analysis. But there was error because those were incorrect statements of law. It's clear and obvious under the authorities that I just talked about. It affected substantial rights, including the right to a fair trial, your Fifth Amendment right to have the elements of the offense proven against you beyond a reasonable doubt, 14th Amendment right to due process. This resulted in a conviction to Mr. Pinaula, for which he was sentenced to 8 years in jail. So I would submit that we met the elements of plain error. And with respect to the people's citations to a couple of cases, People versus Howard, where there was an improper appeal for sympathy, where the prosecutor said, will you be able to live with yourself? That's a little bit different than telling a jury that you apply a sleep test in your evaluation of the case, or that because Mr. Pinaula was involved in some way, even though he wasn't charged with conspiracy, complicity, or criminal facilitation, that's enough when it's not. That's a different type of situation. And in State versus Moorhead, the prosecutor commented on the prevalence of crime and the necessity of law enforcement as a deterrent and the evil which results which may befall a community when a jury fails in its duty. Well, that's different than telling a jury to disregard its duty, specifically its duty to apply the instructions to the facts of the case and to apply the law to the facts of the case. And that's why those cases are distinguishable. And for the reasons I've argued before, I would ask that the court not dismiss the appeal. If it does agree with the government, then I agree that it should be applied prospectively rather than retroactively. And on the merits of the appeal, that the evidence was insufficient to sustain the conviction, even applying the standards for motions for acquittal and de novo review. And that the prosecutor's comments were plain error that warrant reversal. And the admission of hearsay also constituted plain error. And that was the only nexus, arguably, that connected Mr. Pinaula to the alleged offense. And even at that, it was insufficient. But still, it was plain error, which should result in reversal of the conviction. Thank you, Your Honors.
Thank you, Mr. Paris. Any other questions?
Mr. Paris, would you care to comment on the fact that the court dismissed charge 2? Did it that impact your argument at all?
Well, I think it's a recognition of the weakness of the government's case. And charge 2, from what I remember, was the lamp issue.
Yes.
And the remaining, which left the remaining charge, the vehicle. But the evidence as to both was insufficient. The only difference between, I think it was the lamp and the truck, was the location of where the articles were found. The lamp was found in another location, which was not near Mr. Pinaula's residence, and the truck was found near Mr. Pinaula's residence. Still near, there are no facts which show how it got there, what Mr. Pinaula knew. If the admissibility of Mr. Herbert Pinaula's statement that Williams said that it was his friends, even that would be insufficient, I would submit. The government didn't prove where, on whose property that truck was. I think the court properly pointed out that the truck was obscured by vegetation and could not be seen by the road. But I think that the trial court should have granted acquittal of the remaining charge as well, for the reasons that I've stated.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Ferris. Thank you,
Thank you.
counsels, for your arguments this morning. The court appreciates the presentation. We will take the case under advisement, and the court now stands adjourned.
Thank you.
Have a good
Thank
day.
you.
Thank
You
you,
too.
counsel.
Thank you.